All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for oral argument in Thompson versus Manten. Our cause number CV220457. Counsel, we've read the briefs. We've discussed this matter at conference. So keep that in mind as you present your argument. Both sides have 20 minutes to present their argument. Mr. Abney, if you want to reserve any time, it's up to you. And with that, when you approach the podium, if you'd please announce who you represent. And Mr. Abney, you may begin.
I'm not quite sure who I represent.
They all blend after a while.
Yes. May it please the court, my name is David Abney, representing the defendants appellants. I'll probably just usually refer to as Vanessa Manten or Manten. I got 2 C's in law school, and one is my first semester from Professor Dobbs, and I deserved it. He did a multiple choice test, which I didn't expect. They always said he was going to. And I blew it. But I took every course in remedies and torts I could take after that with Professor Dobbs. I never got anything above a B, but I never got a C again. And I brought his book with me today. If we get to talk about Reformation, he has a great deal to say about it. Very bright gentleman. It seems to me like a fairly straightforward proposition that if people deed property into a trust, the 1978 trust, and it's not deeded out of the trust, then the property remains in the trust. And you have to deal with that reality instead of trying to reform contracts. Here, the three deeds were into the trust. And the trial court said, basically, I don't think the trust ever existed, or we don't know what the terms are, don't know what to do with this, so I'm going to reform.
Well, that's correct. We don't know what the terms are.
That's
right?
True. We don't. But
it's never been presented.
There was a half-hearted effort to try to find out something about the trust. Basically, a request for documents from Wells Fargo, and the Wells Fargo said, no, we don't have anything, and that was just dropped. But as I was getting ready, took over this appeal and getting ready, I wondered to myself, well, maybe this trust did other things. And just to take a look on the internet at the records of the Maricopa County Recorder, and the trust was fairly active. From 1978 to 1990, there's 14 recorded transactions of various kinds in the records of the Maricopa County Recorder's Office. So, and I asked the court to take judicial notice of that, and perhaps you will. That's in your discretion. But they are public records, and I think they do help assist that this is not just a phantom, a figment of somebody's imagination. This trust existed, was doing business. And I think an examination, if this is remanded, a focused, diligent examination of the records will actually unearth the trust itself.
But even if we agree with you that a trust existed, the very face of the document that placed the question properties into the trust,
right,
specifically denote that the Bakers are the beneficiaries are the grantors. And we have no other evidence, do we, that any other beneficiary existed under this trust?
We don't know of any others. And we can't know until we find the terms. But we do know that...
Well, that may never happen.
It might never happen. But then there's a proper remedy for that. What we do know is that the deeds went into the trust, and all right title interest of the Bakers was deeded away into the trust. So that's where all right title interest of the property remains in the trust. The remedy is...
Well, it's not just that we don't have any other, well, that we don't have evidence of any other beneficiaries, but the Superior Court actually followed a procedure to try to find other beneficiaries, didn't it? Through publication, and no one came forward.
I don't know about the publication part. I don't remember that being part of the record. What I do remember is that the other side went out and did some investigation, at least to the extent of trying to get documents from Wells Fargo, which is the successor of the successor of whoever started the financial institution that started this whole mess. And I
Great
think that's all
Western.
that was done.
Great Western.
Great Western, yeah. But Great Western transmuted into something else, and I think into something else, and then finally Wells Fargo took over. But the remedy is fairly straightforward. The trustee has died, and when a trustee dies, there's a specific statute that says you can appoint somebody else. You can appoint.
But hold on, because if the trust name, and we know that because I'm looking at the deed.
Right.
That says that you have co-trustees.
Right.
In the two Bakers.
Right.
And they're also the beneficiaries.
Right, that's often happens.
Right, so if they, as the trustee and the beneficiaries, decide to sell things out of the trust or move items, they can do that, can't they?
Absolutely, but you have to do it through the trustee of the trust. You can't just, on your own, do a separate deed, special warranty deeds, and say, I'm going to deed this property away to somebody else. It has to become out of the trust and then get deeded somewhere else. But the remedy is, when a trustee dies, is you go to the
So
trustee.
the sole error that you're claiming that causes this problem is simply that when the trustee, the Baker, did the 1998 deed,
Right.
that he omitted the term, well, they say that he omitted the term that he was doing this on behalf of the trust, that he was a trustee doing that, that he was putting the property from the 78 trust into the 98.
You're in the right church, but definitely the wrong pew. It had to be done in his capacity as a trustee to be effective at all. And anything else is ineffective, and the property remains inside the trust. And the remedy is, when a trustee dies, you appoint somebody who's designated in the deed, in the documents as trustee, so forth. But the last thing you do, if you can't figure out any of that, you appoint a person then to act as trustee. And the person, I think, the statute doesn't say anything other than a person, but I think would have to be somebody objective, somebody who's not
Well, before we get to a remedy, we always have to find an error. And I'm struggling to find the error if the only omission is the fact that he didn't put on the transfer that I'm doing this as a trustee.
Well, you can't do it any other way. There's the only way to get property out of a trust is to go through the trustee properly with a proper deed. You can't just out of the blue say, I'm going to transfer certain property. And they don't even say that I used to own, then it went into a trust. They didn't do any of that. They just purported to transfer property. And all of those deeds and other documents that aren't made in the capacity of trustee of the 1978 deed, 1978 trust, are a nullity. They don't count for anything. You have to do it very specifically. I mean, the common law on this developed over centuries and with incredible precision. You had to do it exactly the right way or it was ineffective. But there are remedies. The remedy here is to appoint a person to act as trustee, and I think that subsumes within it an objective, dispassionate, qualified person to act as trustee and decide what to do with the property, where it's supposed to go. But wherever it's wandered off, as far as these invalid deeds, it's not there. It's in the trust. These three properties are in the trust. They've always been in the trust, and they're going to stay in the trust until somebody does a valid transfer out of the trust. And the only way to do that, I think, is to appoint a new trustee. I would submit an objective, dispassionate, third-party kind of trustee.
What interest does your client have in the 78 trust, and where does that interest come from?
She is a potential beneficiary, but she was sued as part of the quiet title action, so she has standing to raise these issues. And I know they said she doesn't, but if you get sued and they're after you for attorney's fees, costs, and remedies that are going to affect your actual and potential rights, you've got standing. Standing to be.
Sure, she's got standing, but what claim does she have to withstand the quiet title?
She has standing to challenge what's
She has
happened.
standing, but on the merits, what's her claim to the property?
She doesn't know exactly what her claim is at this point because everything has been done improperly. I mean, nobody's found the trust documents, and in lieu of finding the trust documents, nobody has appointed a proper trustee to decide what to do. 'do. That trustee has the power to decide what to do, of course, with judicial oversight and the at the end. I mean, and you can challenge if the trustee says, well, I think,
Mr. Abney, is there any evidence at all that anything remains in the 78 trust?
yes,
What?
the 3 deeds to
Okay,
the
well,
property.
that is the only thing, you're the appellant, which means you lost in that point. But you did this title search, and you went out and you found all sorts of 78 trusts. Are any of those still appear to be in the 78 trust? Or have they all been sold out of the 78 trust?
Not as far as I know. And the 78 trust was dealing with other properties, too. That's what these deeds indicate.
Right, I think Judge McMurdy is asking, are any of those other properties still in the 78 trust, as best as you can tell?
Other than the original 3, I don't think so. I think everything else was dealt with, but these 3 are just, they're right. Legally, in the legal universe, maybe it's an alternate universe, but it's the one we live in, those 3 deeds are in that 78 trust and they haven't moved out of it. And they can't move out of it until there's a proper remedy from the Superior Court to start the process to move them out, which is first number 1 step is to get a trustee appointed and then have the trustee decide what to do.
Your client was sued for attempting to convey these properties to her own trust, wasn't she?
I don't know who came up with that idea. And it's,
The idea to try to convey them?
yes, yeah, it was stupid. Pardon my expression, stupid. I hate to say it about my.
And when she tried to convey them, she tried to convey them out of the roll-off trust, didn't she?
Yeah,
Right.
she
And in poker terms, isn't that a tell?
No, that is not understanding property law and having a lawyer who doesn't understand property law advising you about property law that you don't understand and that the lawyer doesn't really understand, and you get into a mess. In
Well,
which
apparently Garrett Baker didn't know that either, because he didn't put, I'm not doing this as my trust, as the trustee when he
Well, yeah.
transferred the property. So,
But, you're a trustee, you have duties that devolve upon you by statute and by case law and by common law, and you have to fulfill those duties if you're going to handle the trust properly. And trying to transfer doing these deed transfers when you don't own the property, you don't have control of the property, that's not right. That's not how things are done.
But he would have control of the property if the 78 trust had been revoked, right?
If it had been revoked,
Right.
well, he wouldn't be trustee. I don't know what would happen at that point.
Right. But if he wasn't trustee and he held them, and the trust had been revoked, he then holds them individually, he could then convey them into the 98 trust, couldn't he?
If the trust were revoked and the property transferred out of it, if you just revoke the trust, what happens to the property? Somebody owns it at all times. That's the American way since we kicked out the Native Americans. The American way is somebody owns this property and you have pieces of paper to prove it, and the common law requires this tremendous precision because property was such a value.
And what is your understanding about who would own these 3 properties if the 78 trust had been revoked? By Mr. and Ms. Baker?
All right, hypothetically, if it had been revoked and the property devolved back on the Bakers themselves, then they could have transferred it wherever, willy-nilly, wherever they wanted to, if everything was done properly, but everything wasn't done properly. Nothing was done, except all of a sudden you get these special warranty deeds out of the ozone, and boom, it goes off in a different direction, but you can't do it. Which leads me to Reformation. I just wanted to say, since I brought the book with me, this is the 3rd edition of Professor Dobbs's Horn book, 1993, and he says, Reformation is a restitutionary remedy invoked to avoid unjust enrichment, but in a special sense. When parties come to an agreement, but by fraud or mistake, write it down in some fashion that does not truly reflect their contract, equity will reform the writing to make it reflect the party's true intention. That's section 4.37 of Dobbs' own remedies. And then he goes on to say in section 11.61, reformation of the contract due to the party's mutual mistake continues to be an extraordinary remedy. You've got to have a mistake in the belief regarding a fact, a mistaken belief constituting a basic assumption of the contract. The mistake has a material effect, and the contract did not put the risk of mistake on the party seeking reformation. We don't have any basis for reformation in this case.
But what evidence did your client come forward with on summary judgment that Roloff intended to do anything other than convey that property as trustee?
I don't think there's, hold it. Did I just step into a trap here? I don't know. There's no evidence about what the trustee wanted to do. The trustee of the 78 trust. We have no evidence about that at all. All we know is the 3 deeds went into the trust, that's where they stay, and then you get a person who happens to be trustee, but not acting in capacity as trustee, and his wife deeding away things. It just doesn't fit.
Well, it's more than
trust.
that, because based on what, if we find a 78 trust existed, we find that the Bakers were the sole beneficiaries of that trust, right? Because that's what it says.
Yeah.
And if they're the sole beneficiaries of the trust, they can revoke the trust.
You've got to go through the forms. You have to follow the proper form. You have to have the trustee be deeding stuff. You can't just willy-nilly have the beneficiaries doing stuff. That's not how it works.
But when people don't do the right forms, don't we turn to equitable remedies?
Right, which would be, well, in this case, it's a statutory remedy. Reformation doesn't fit. That's not the right remedy. It sounds nice, but it's not. Reformation is a very specific remedy. What you have here is a statutory remedy about what happens when a trustee has died. I think that's the remedy that fits. And if you go down the steps in the statute, you can appoint a person to act as the trustee when the original trustee has died.
If the properties made their way into the 98 trust and the Bakers die, there's no dispute that roll-off then becomes the successor trustee.
Of that
Entity. Right. What evidence did your client come forward with then that when the properties were conveyed out of the 98 trust into the roll-off trust, that roll-off was doing that in any other capacity than as trustee, and therefore that reformation isn't appropriate?
Well, he'd have to say I was acting as trustee for the 1978 trust at some point.
No,
In none of these transactions does that happen.
That's not the question. The question he's asking is in the 98 trust.
Yes.
Is there, when he attempted to move the properties out of the 98 trust, he was the sole trustee and the beneficiary of that trust.
Right.
Correct.
It's still a nullity,
Okay.
to answer that question. Well, unless something happens with the 1978 trust, the property is still in there. You can't deed things you don't own as in the capacity of the trustee that you don't have control over as trustee. You just can't do it. You know, and I put in Billy Preston in there, nothing from nothing leaves nothing, and that really is the situation here. You can't manufacture out of thin air ownership rights to these 3 properties. You have to go through the proper steps in the 1978 trust to get them out of the 1978 trust, and at this point, they're still there. Any other further questions?
No, I was wondering if you were going to reserve your time.
I'd love to reserve some time, Your Honor.
All right, you may do so. Counsel?
Good morning, may it please the court. Christopher Herring representing Madison Thompson as the trustee of the roll-off Edwin Manten Trust, and for simplicity's sake, not to be deliberately informal, I will refer to the first names of Vanessa and roll-off, because otherwise things get confusing very, very quickly. I think it's important to understand, and this is to a point Judge Catlett was making while Mr. Abney was up here, I think it's important to understand what's really happening in this case. We have 3 people who are deceased who have done estate planning. We have Garrett and Katharina Bacher, and then we have roll-off Manten. Those 3 individuals have done estate plans. The evidence is incontroverted about what their intent was when they passed away with respect to their properties. We have a party, Vanessa, coming in wanting to disrupt that and claim entitlement to these 3 houses all for herself, and disrupt, at a minimum, 25 years of estate planning. And so that's the idea. The whole idea of this matter for Vanessa is to take this real estate for herself, and she's looking for any way to do that. There's a lot of merits discussion I'll obviously get into, but I want to begin with at least one issue of procedure, which is the standing question. So one point of clarification is that we did not sue and name Vanessa Manten as a potential beneficiary of the 1978 trust. If you look at the operative complaint, the caption and the allegations name the unknown trustees and beneficiaries of the 1978 trust, because we don't know who those are. We don't know. And that's a process it's similar to when you sue an unknown error under Rule 4.1, and I'm blanking on the subsection at the moment, but it's in Rule 4.1. It was Vanessa Manten who filed an answer appearing and claiming status as the potential trustee or the potential beneficiary of this 1978 trust.
When you follow the procedure that you followed, how is notice given to potential beneficiaries, or how is service affected?
Yeah, so service is affected by publication. We went through the publication process, published 3 times in a newspaper of record. And for all we knew, the Arizona Humane Society or ASU or anybody else could have appeared and said, hey, we have a copy of this trust. We think we're the beneficiary. And then we have to deal with that at that point. We have to deal with the ramifications of that. But nobody else appeared other than Vanessa Manten. What the problem for Vanessa in claiming that she has entitlement to do anything with respect to this 1978 trust is she presented no evidence of transforming herself from a potential beneficiary to an actual beneficiary. She presented absolutely no evidence on that point. No trust document, no testimony from anybody, nothing. Transforming that would make her and give her status to do anything with respect to the 1978 trust. As far as we understand it, she's a stranger to this trust document, and what I think is really happening is Ms. Manten's trying to apply the rules of intestate succession to say, well, I have to be a beneficiary of this trust because I'm the granddaughter. I have to be. Well, that's not how it works with trusts. Trusts are agreements, and we deal with that in the written instruments that are produced by the parties.
If she shows up, though, and says, I'm a beneficiary of this trust, that's enough for standing, isn't it? Whether she then can come forward with evidence to actually establish that fact is a merits question, and I just want to make sure we're not mixing those two.
Yeah, I think that's enough. That would be enough to survive a Rule 12 motion. I think that if she has an allegation, hey, I'm a potential beneficiary of this trust, I don't think, and we did not seek a Rule 12 dismissal on that ground. But and I kind of called it standing, and maybe that was imprecise. But the general idea was, in order to claim any status under this trust, she has to prove she's a beneficiary. She has to prove that. She never did so, and so that like I say, I've called it standing. Maybe that was a bit imprecise, but the point I think still remains the same. So, a few words on the 1978 deeds. Just a few words on those. So, Vanessa's putting a lot of stock in what she's saying is this remedy of appointing a trustee to represent that trust. Well, two comments on that. So the first comment is Vanessa tried to do that already. Vanessa went to the probate court and tried to get herself appointed as trustee and as beneficiary of the 1978 trust. Vanessa was unsuccessful in that, and she never appealed that determination. The probate judge concluded, and this is in our papers, the probate judge concluded basically if you don't have a trust document, I can't appoint you as a trustee. I can't appoint you as a beneficiary. We don't have a document. We don't know what the terms are. But even if I assume that Title 14 would at some point allow Vanessa to be appointed as a trustee, nothing changes. You can't appoint her as a beneficiary, and so play it out and assume you appoint Vanessa as a trustee. Well, what happens? Where does the real estate ultimately go? We still don't know. We have no idea. None. And so she's the trustee of a trust for which there's nothing to do. Maybe it's inaccurate to say nothing to do, but there's no direction on what to do. You would have to have a probate court basically create a trust that we have no idea ever existed. None.
We do know it existed. I mean, we know it from the public records, and I think we know it from the very face of the 78 documents that attempted to transfer those properties into the trust. But the things we know about it based on the face of that document is that, you call them Bakers or?
Bakers.
Bakers,
yeah.
Okay, well, I've been saying it wrong. The Bakers list themselves as the trustees and the beneficiaries. Isn't that enough? Yeah, I mean, they are the trustees and they are the beneficiaries. So,
And you know what the property
and you know the property.
is.
Well, how
To
it usually-
establish that it went into the trust.
Yeah, I mean, it may have been that there was an extant trust in 1978. The question is there an extant trust today where we can do anything with it? And, we cite a restatement section, restatement of trusts, where, and you see this usually in the charitable trust context.
Well, I'm not so, I'm trying to move you a little forward because you're running out of time. Let's now go to 98.
Yes.
And the attempted transfer from the 78 trust to the 98 trust. At that point in time, couldn't the Bachers revoke putting that property into the 78 trust? They're the trustees and the only known beneficiaries we have for the 78 trust. So isn't that enough for them to transfer the property?
Yes, they absolutely have the power to revoke their own trust.
And at least to that part of moving the property out of the 78 trust, assuming that other properties still remained in the 78 trust.
Correct. They could keep some properties in hypothetically, you could have two trusts. You could keep some properties in one trust and move some properties into another trust. That's definitely possible. Yes, that's absolutely.
So if we look at the 98 deeds where the Bachers attempted to move the property from the 78, the only thing that's missing is the term that they were doing it in their capacity as the trustees.
Exactly. That's the only thing that's missing. That's exactly right.
Can we infer, and I'm leading you down the primrose path here, but can we infer that they actually were, in essence, revoking that part of the trust?
Yeah, I think as to those three properties, yes. I think you could infer that. I think that's a fair inference to draw. So at the very least, they didn't want those three properties to be in that trust anymore.
Is that partial revocation then?
I mean, I suppose that depends on whether there were other assets in the trust at that time. I mean, were there bank accounts, were there vehicles, and we don't know the answer to that. But at a minimum, it's a partial revocation, at a minimum.
Well, I guess Mr. Abney's client has identified other properties that went into the 78 trust, and if we don't know then what happened to those, does that create an issue?
I don't think so. I mean, as far as I could tell, none of those properties are still in the trust. I'm with the caveat I'm not a title examiner, and so, but as far as I could tell, none of those other properties that would have the legal descriptions distinct from the three we're talking about, the chain of title all got closed on them.
Right. On the issue of the existence of the 78 trust, the parties haven't really framed it this way, but I view it as a statute of frauds issue. The statute of frauds applies to trusts that hold property, correct?
Yes.
Why, your client's primary argument is the 78 trust failed, and I guess why is what we have insufficient to satisfy the statute of frauds? Is it because we don't have the trust agreement?
We don't have a trust agreement. We don't have a trust agreement, and to the point that, keep in mind that the defendant it's not Garrett and Katharina Bacher personally. The defendant is Vanessa Manten. And so we don't have a document showing Vanessa Manten to be a beneficiary. Whatever the deeds in 1978 might have said about the Bachers being beneficiaries, we have nothing dealing with Vanessa Manten being a beneficiary.
And I guess what support do you have for the proposition that you need the trust agreement in order to satisfy the statute of frauds? Because my understanding of the statute of frauds is you could have pieces of paper all over the place, and as long as you can sort of bring them all together and they're documents and they're signed by the party to be charged, that's sufficient. And so why are the deeds then not sufficient?
Well, just as a preliminary matter, yes, you can have multiple writings. I mean, obviously in this world, the most common kind of writing is the trust instrument. I suppose if you had a set of email exchanges, I suppose that would be sufficient. But again, we don't have that as to Vanessa Manten. We don't have anything about that. We don't have anything with Vanessa Manten showing that Vanessa Manten is a beneficiary of this trust.
Of the 78 trust.
Of the 78 trust, correct.
Right. Your client doesn't dispute that she is a successor trustee of the 98 trust, right?
Correct. No, Vanessa is the successor trustee. That's correct. of the.
And so if the property never made its way out of the 98 trust, then she clearly would have an interest in the property.
I'm sorry, could you say that again?
If these three properties made their way into the 98 trust, but never made their way out, she would have an interest in those properties as successor trustee.
Yeah, I mean, I think there would be, we would certainly have other arguments to make on that, but Vanessa Manten would be the successor trustee and would, in that event, let's say hypothetically there was no deed at all conveying the properties from the 98 trust to the roll-off trust. In that event, I think, yes, the properties are titled in the name of the 98 trust, and Vanessa is the proper successor trustee of that trust. But actually, just to go to just quickly on the Reformation issue, I think as Judge Brown pointed out, mistakes do happen. In a perfect world, all these documents are done correctly, everything goes smoothly. But especially when people don't involve attorneys, things sometimes just don't go that way.
Sometimes, actually, when they involve attorneys, we get to the same point.
To be fair, yes, to be fair. To be fair. But
Counsel, can you explain that? What kind of mistake is this? What's the nature of the mistake? Is it a mutual mistake or a unilateral mistake?
this is a mutual mistake because
It's the same people. The parties, who made the mistake?
Roloff Manten would have been on both sides of the deed in 2010. Roloff Manten was the successor trustee and signing on behalf of the 1998 Bacher Trust, and Roloff Manten was signing or receiving the properties on behalf of his own trust. Roloff Manten, it's the same physical, biological person, but he occupies different capacities. This is not a situation sometimes you'll see, which I think it's in like the SWC Crisman case, where you have an arm's length transaction and there's an argument about a legal description or something like that. But it's an arm's length transaction between two entirely separate people and entirely separate parties. And this is a situation where it's mutual because Mr. Manten is the only person. He just occupies different capacities, and both trusts are legally distinct from one another.
Have you cited a case, or are you aware of a case that applies mutual mistake with this type of situation?
Yeah, the closest case is Thompson v. Conan, which we cite. That's on, I'll get you a page number. That is a situation where the individual, kind of similar to this case, the individual who is signing a deed makes a mistake as to her capacity in when she signs the deed. So this is on page 23 of our brief. It's a case from the Missouri Court of Appeals. We had to cast a wide net on this one. And so the basic facts are fairly similar to this case, in that you have a lady that signs deeds conveying real estate into a new trust. We've called it in that case, like there's the new trust and then there's a joint trust. Similar to this case, the grantor did not first deed the property out of the new trust, out of the joint trust, before she deeded it into the new trust. She did it in her individual capacity. The court reformed the deed to say, no, she did it in her capacity as the joint trustee. She did it in her capacity as that, because the court found the mistake on the face of the document. On the face of the document and on the face of the surrounding circumstances. And the surrounding circumstances here on the 2010 deeds are quite clear in that these deeds are executed just weeks after Mrs. Bacher passed away, which at that point, Mr. Roloff Manten, became the sole trustee of the trust, of the 1998 Bacher Trust, and was the sole beneficiary. None of that's disputed by Vanessa. And I think equally important, back in 2010, when these deeds were executed, Vanessa made no effort to object to the deeds, made no effort to say, hey, this is wrong in some way. I think I should get the properties. I think there's some irregularity in the process. In Judge Catlett's words, that's a tell. That as far as Vanessa was concerned at that time, everything had been done on the up and up.
Well, that presupposes she was aware of it.
She was aware of it. I don't have a specific cite for it. That came out in the deposition. She was aware of it.
Okay.
She was aware of it.
So if we look for it, it'll be in this record.
Well, it would, I believe it's in the summary judgment papers.
Okay.
I believe it's in the statement of facts where it establishes that Vanessa's aware of it in
Of
2000.
the 2010 transfer.
In 2010, yes. Aware that Mr. Manten Roloff, broke my own rule, Roloff transferred the property from the 98 trust to himself. So, I think unless the court has any other questions for me, I think I'll rest on that.
All right. Thank you, counsel.
Thank you.
Mr. Abney, any final word?
Okay, as far as the nature of the mistake, it looks like it's a unilateral mistake. The trustee did not do what the trustee was supposed to do. If the trustee wanted to transfer property out of the 1978 trust, the trustee had to follow the proper forms. As far as statute of frauds, you can certainly cobble together a trust, a contract, a deed out of different pieces of paper, but you have to have, when you're dealing with a trust, you have to have the trustee doing something. Now, there could be a palace revolt of the beneficiaries, but what they do in the palace revolt then is to replace the trustee. They don't just go off on their own and start deeding things away. There's no indication here that the trustee did things properly in any way to transfer anything out.
You know, I hate to keep beating this, but there is no evidence that there were any other beneficiaries in the 78 trust.
No evidence one way or the other, Your Honor. But the proper
Oh,
way...
it says right on the deed that they are the beneficiaries.
But there's only one proper way to get the property out of the trust. Once it goes in, the trustee has to deed it out. And the only trustee was Garrett Bacher? I'm sorry about pronouncing Baker before. Bacher.
Well, and there's a statutory procedure for trying to locate other beneficiaries, and it seems like that was followed here. At least your client hasn't made the argument that it wasn't followed or appealed from the Superior Court's determination that there were no other beneficiaries.
But that doesn't solve the problem. The problem is the trustee had no power, no right, no title, no interest, no nothing to transfer out. In fact, the beneficiaries on their own had no right, title, interest, and whatnot. It was in the trust. And the trustee is the one that had to transfer the property out of the trust. Otherwise, we get into a bleak house where the litigation goes on for decade after decade, and the only people that make any money out of the whole mess are the lawyers fighting over this. That's why the common law and the statutory law requires us to follow very strictly the procedures and the steps that need to be followed. And the ultimate step here that needs to be followed now that the trustee is dead is to get a person appointed as trustee and have that person decide what to do with, of course, the right of anybody who's interested to object to it.
Mr. Herring correctly points out that your client attempted to do that, and it was revoked, and you didn't appeal. I mean, it was denied, and she didn't appeal.
I'm not sure what she was doing. What she was doing was not the proper way to go about it, and it really had no effect at all. The property remains where it was put originally and can only get out of there when a validly appointed trustee does something about it. And we don't have a validly appointed trustee to do anything at this point. We simply have a trust sitting there holding these three items of property in the legal ether, and that's where they sit in a legal sense. They can't get out of that until a trustee with proper authority deeds them out of that trust, and that has not happened. We talked briefly about standing. My colleague, I noticed, said that the defendant is Vanessa Manten, which is absolutely correct. When the first amended verified complaint named her and John Doe Manten as defendants, and she's been in this dispute from the beginning. So she does have standing to try to figure out what to do here. But what to do here is really to fall back on the common law and on the statutes and say, you have to follow these steps. You can't sidestep them. You can't go around them. You can't just have beneficiaries deeding things away. It has to go through the trustee. And until that happens, those three items of property remain in that trust. I mean, that leaves us a lot to work out at the Superior Court, but Superior Court judges are smart enough to do that. And if there's any problem, then I can come back here for my monthly lesson in humility. Thank you very much.
All right. Thank you, Mr.
Thank you.
Abney. The matter is deemed submitted. We'll issue a decision in due course. Court's in recess.